Hi guys! Welcome to another episode of Attorney Vlogger, Law for the Everyday Layman. Today we take up part 11 on the law of obligations and we talk about obligations with a penal clause. So if you like my videos and you want to see more, please hit the subscribe button. Also, please remember that this is only for educational purposes and is not a substitute for proper legal advice or for studying and understanding the law. Okay, now before I discuss obligations with a penal clause, let's differentiate principal obligations from accessory obligations. When we talk about principal obligations, these kinds of obligations can stand by themselves. Why? Because their validity or existence do not depend on another obligation. And that is why they can stand by themselves. While accessory obligations, they cannot stand by themselves because they are attached to a principal. Therefore, the rule is accessory follows the principal because the accessory cannot stand or cannot exist without a principal to which it is attached. Okay? So when we talk about obligations with a penal clause, these are obligations that contain an accessory undertaking or an accessory obligation to pay a previously stipulated indemnity. Okay? In case of a breach of the principal prestation or obligation. Okay? In other words, the penal clause is merely an accessory obligation, okay? Which comes into effect once there is breach of the principal obligation. And what are the purposes of a penal clause? There are three, no? First, function coercitiva. This is to ensure performance of the obligation on the part of the debtor to make sure that the debtor performs his obligation. Second, function liquidatoria, no? This is to serve as the liquidated amount of damages to be awarded in case of breach of the principal obligation, okay? In other words, it's compensatory. It compensates the creditor for the damages suffered, in which case the creditor can no longer claim additional damages, okay? And finally, third purpose, it's to punish the debtor for breach or function estrictamente penal, okay? So in this case, this does not serve as damages and does not resolve the question of how much the creditor will be entitled to in case he has suffered damages. Okay? Now, let's start with the rules. First general rule, the penalty serves as the substitute of damages and interest in case of non-compliance or breach of the principal obligation. But that's the general rule, okay? You may have already heard an exception while I was talking earlier, no? As a general rule, if there is a penal clause, that amount will serve as the substitute of damages and interest. So the creditor should not be able to claim damages or interest anymore. Okay? However, there are three exceptions. Okay? First, of course, is if the parties so expressly stipulate or agree. Okay? In which case, if there is an agreement, then the creditor can ask for damages or interest even though there is a penalty. Okay? Second, in case the debtor refuses to pay the penalty, in which case the creditor can recover legal interest. Okay? And finally, third, when the debtor is guilty of fraud in performance, the creditor may recover damages. Because if you remember our discussion on fraud, liability for fraud is demandable in all obligations. Okay? Let's go to the next rule. As to enforceability of the penal clause, the penalty is only demandable if there is a breach. Okay? If there is no breach, then you do not demand the penalty. And of course, the penal clause must not be contrary to law, morals, good customs, public order, or public policy. Okay, now that rule does not apply to reciprocal obligations in case both are unable to comply. If both are not able to comply, there is no penalty due because there is no breach yet. Okay? Now, let's move on to the next rule. As a general rule, the debtor cannot excuse himself from performing the principal obligation by simply paying the penalty, okay? Because some debtors may say na it's easier to just pay the penalty because performing the obligation will be too hard. The law does not allow that, Okay? This is because the debtor should be bound to perform his obligation in good faith. Okay? However, there is an exception, and the debtor may relieve himself from performing the obligation by simply paying the penalty if the parties so expressly and clearly grant that right to him by stipulation. Okay? Now let's go to the next rule. As a general rule, the creditor cannot demand performance of the principal obligation and demand the penalty at the same time. Why? Again, the penalty serves as insurance of performance, as liquidated damages, or to punish the debtor for breach. No? So if there has been no breach yet, then there is no reason for the creditor to ask for satisfaction of the penalty. Okay? So as a general rule, the creditor cannot ask for performance and the penalty at the same time. Okay? This is accepted the case of when the right is clearly granted to the creditor. Okay? If the creditor is allowed to ask for performance and the penalty at the same time, and this is expressly granted, then the creditor may do so. However, in the absence of express stipulation, then the creditor must only choose between asking for performance or asking for the penalty. Okay? However, take note of this modification of the rule. No, if the creditor has demanded fulfillment, but the fulfillment has become impossible without the creditor's fault, then the creditor may demand the penalty. Okay? And if with the fault of the debtor, the creditor may additionally claim damages. Okay? All these rules that I have talked about is based on the principle that the penal clause is deemed subsidiary because the primary purpose is to urge or ensure performance of the debtor. Okay? Okay. Now, proof of actual damages is not necessary, no? Proof of actual damages which was suffered by the creditor is not necessary to demand the penalty. What does the creditor have to do? All he has to do is just to prove that there was a breach, no? That the obligation was violated, and then he will be entitled to the penalty. Okay? He does not have to prove the actual damages. However, if the creditor does decide to prove damages, he will not be entitled, no, to recover more than the penalty. Hanggang dun lang siya, no? He's only limited to the amount stipulated to serve as the penalty. Even if he proves that the amount of damages exceeds the penalty. Sorry na lang siya. Okay? Hanggang doon lang siya sa penalty because the penalty serves as a substitute for damages. There is an exception when the creditor may claim excess than the amount granted to him under the penalty, and this is when the right is granted to him clearly or when there is fraud. Okay? Now, finally, courts are given power to equitably reduce the penalty. Okay? But not in all cases. Only in the following cases. Courts may reduce the penalty first, no? If the principal obligation was partially complied with. Okay? Second, if the principal obligation was irregularly complied with. And finally, if the penalty is iniquitous or unconscionable, meaning shocking to the conscience, it's so gross in character that a normal person could not stomach it, even if there is no performance yet. As long as the penalty is so iniquitous or unconscionable, even if there is no performance of the principal obligation. Now, the last rule is that the nullity of the principal obligation, of course, carries with it the nullity of the penal clause. If the principal obligation is void, then of course there is no more penal clause to talk about, no? Why? Because again, the accessory follows the principal. The penal clause is the accessory obligation, and it follows the principal obligation. So therefore, if the principal obligation is void, then the accessory obligation is also void. The converse is not true, ha? If the accessory is void, the principal obligation may still be valid because the nullity of the accessory obligation of penal clause does not carry with it the nullity of the principal obligation. Okay, so that's it for obligations with the penal clause. This marks the end of obligations, and you can proceed to part 2 of obligations and contracts by clicking on the link below to the playlist on contracts, or if you want, you can just watch the next video on this series on natural obligations and estoppel. Okay, that's for additional knowledge. Otherwise, just proceed to part 2 of Oblicon on Philippine contract law. Okay, so that's it. I hope you may have picked up a thing or two, and I hope to see you next time. Okay, bye.